the bitter Irish race memory of politically appointed and executive-oriented judges, of the suspension of jury trial in times of popular revolt, of the substitution, therefore, of summary trial or detention without trial, of cat-and-mouse releases from such detention, of packed juries and sometimes corrupt judges and prosecutors, had long implanted in the consciousness of the people, and therefore in the minds of their political representatives, the conviction that the best way of preventing an individual from suffering a wrong conviction for an offence was to allow him to put himself upon his country. That is to say, to allow him to be tried for that offence by a fair, impartial and representative jury, sitting in a court presided over by an impartial and independent judge appointed under the Constitution, who would see that all the requirements for a fair and proper jury trial would be observed.
Welcome to the second series of the Irish Courts podcast, where we continue to explore the impact that significant cases and legal change has had on Irish society. The words you have just heard are those of Mr. Justice Seamus Henchy in the case of People DPP versus O'Shea in 1982, which articulates the importance of the right to trial by jury in Irish law for serious criminal offences. In this episode, we explore into the history, evolution and continued importance of the role of juries in our criminal justice system. Niamh Howlin, Associate Professor at the UCD Sutherland School of Law.
Yeah, so a jury is a group of laypersons who are given legally recognised decision-making powers.
It's a constitutional imperative.
Senior Counsel Patrick Gageby.
And the only constitutional exception from it in serious cases is military courts or the special criminal court.
Well, we have this system because the Constitution affords the right to an accused person a jury trial.
Miss Justice Caroline Biggs, Judge of the Central Criminal Courts.
And the reason why a jury trial is so imperative is because the jurors come from our community, bringing with it all their experience, all their wisdom and their knowledge. And it can end up being hundreds of years of knowledge when you look at the 12 people that can be in front of you on a jury. They're far better placed to make the right decision.
Why is it important? The important reason for having juries is that they act as a brake, that's a BRAKE, on overreach by the state, overreach by the Gardaí, overreach by regulatory authorities or prosecuting authorities or anything like that. So that at the end of the day, for instance, prosecuting authorities have to look at their cases and say, would a reasonable jury convict in this case? So I think for that reason alone, juries are an absolute necessity. I think also there is something to be said for the fact that employing lay jurors, lay judges, is a very important part of the confidence that people will have. It is, I think, a great security for accused persons to know that their guilt or otherwise was determined by a jury of 12 men and women and not by trained judges.
And that is kind of the beauty of it, that it isn't just the judges, although we are perhaps more diverse and there's more of a gender balance now than there was previously. The jury system represents a broad spectrum of society, and that's why it's fair. What is remarkable about witnessing a jury trial unfold, the effort, the diligence and the importance that they place in their work, their energy, you can feel it. I think looking back on it, and even looking back over is it now almost 30 years that I've been involved in the criminal justice system since 1997, I have always felt that if you ever want to come down and have your faith in the criminal justice system affirmed, come down and watch a jury.
And These days, we mostly think about a jury in the context of a criminal trial. So we think about them being used in cases of murder and other serious offences. But in the past, particularly in the 18th and 19th centuries, juries were used to decide a really wide range of things. So as well as determining guilt or innocence, they would carry out property valuations, they'd settle business disputes, they would make findings about mental health, and they would check to see if a woman was pregnant. If a woman was convicted of a capital offence and she was going to be sentenced to be hanged, she might plead the belly. And pleading the belly meant you were stating that you were pregnant. If it was found that you were pregnant, then your execution would be postponed until the baby would be delivered. So they would lock the doors of the courthouse and they would get whatever 12 random women happened to be around and they'd send them into a room with the woman, with the defendant, and they would just sort of look at her belly and they'd sort of feel and palpate to see if they thought that she was pregnant or not. And most of the time, if she was successful, the death sentence wasn't carried out in most cases by the time the baby was born. So there were different kinds of juries for those different kinds of jobs. So there was at times an element of danger in being a juror. If the country was in a state of political agitation and tempers were high and stakes were high, sometimes people who were called to sit on juries found themselves in danger. Not to mention all the discomfort that went with it as well. The jury would sit together in a jury box in the courtroom where they could see and hear everything that was happening. And then when it was time for them to go and consider their verdict, they would often go off to a separate room called the jury room. And the idea was that when they were there, they weren't allowed to have any food, fire, candle or water. And that was to encourage them to reach a unanimous verdict sooner rather than later. So to sit on a jury, in most instances, you had to be a man. You had to own property. In the 18th century, so in the 1700s, there was legislation as part of the penal laws that prohibited Catholics from sitting on juries. That was done away with in the 19th century, but there were still some sheriffs who didn't like to put the names of Catholics on the jury lists if they could help it. So to pack a jury was to attempt to fill it with people who would be sympathetic to one side or the other. And that could be done in a criminal case or in a civil case. So a lot of cases relating to the land war, for example. Another example would be the trial of Daniel O'Connell in 1844. So there was an attempt there to pack the jury so that there wouldn't be any Catholics on his jury, with the idea being that Catholics were more likely to be favourable to him and Protestants would be less favourable. Juries in the past weren't representative of society in the way we'd understand it today. To be eligible to sit on a jury, you had to meet certain threshold requirements that related to class, income, gender and profession. So the people who were in the majority in the population tended to be on the minority on a jury. So aside from the very specific instance of the jury of matrons, where a woman claimed to be pregnant in order to avoid the death penalty, no other women could sit on a jury in the 19th century. So it wasn't until the early 20th century that legislation was passed that would allow a woman to sit on a jury. This was an act of 1919, which allowed women to do things like join the legal professions and sit on juries.
This progression of women's rights was retracted in 1927.
So a major piece of reforming legislation that happened in the early 20th century was the Juries Act of 1927. And that essentially said that you had to be a ratepayer in order to qualify for a jury. So in other words, you had to own property and you had to be registered to pay local rates. In most cases, that meant that you were going to be a man, because very few women held property in their own names and even fewer of those were registered as ratepayers. If you were a woman who owned property and who was a ratepayer, there was an additional hurdle that you had to actively try and opt in for jury service. You weren't automatically included, so you had to take steps to be included. Very few women did opt in, and if they did, they were likely to be challenged by one of the parties to the case. So the reality of the 1927 Act was that it was almost unheard of for a woman to sit on a jury in Ireland in the early part of the 20th century. Women were seen as being maybe too delicate to deal with the gritty reality of the kinds of evidence that would be adduced at trials. And some people were particularly opposed to women sitting in on murder trials or sexual offences trials in particular. There was also then the idea that it wasn't really a woman's place to be on a jury. That was the public sphere, and women should really be in the private sphere. They should be in the home. A lot of this comes back to the idea of the role of women, particularly in those years post-independence, the post-revolutionary period, when we saw a retraction of women's rights and a kind of a shrinking of women's public role and public persona.
A 1965 report by the Committee of Court Practice and Procedures on Jury Service had recommended the abolition of the practical bar on women serving on juries. However, it would be a further 10 years before that reform would finally come. The report is notable for a strong minority view that women were unfit for jury service. The minority expressed the view that if a married woman returns to her home at 7 o'clock in the evening and finds an irate husband and 3 hungry children waiting for her, we think it unlikely that they would accept jury service as a convincing excuse. Changing this perception of women's place took decades of challenges by individuals, civil rights organisations such as the Irish Women's Liberation Movement, and groundbreaking legal cases such as de Burke and Anderson in 1976.
So Maureen de Burke was a very well-known social activist in the 1960s and 70s. And one of the many causes that she was involved in was housing rights. So she co-founded the Dublin Housing Action Campaign. And she was involved in various different protests about the very poor quality of rented accommodation in the late 60s and early 70s. And one of these demonstrations that she was at took place in 1971 outside Leinster House. She was there with her friend Mary Anderson, who was a journalist, and others, and they ignored a police order to disperse. And then they were arrested and charged with obstructing a police officer.
And we were demonstrating outside the Dáil and we were arrested. And we had Dudley Potter was my solicitor. And he said, you know, Maureen, he said, I think given your kind of history, maybe we should go for a trial by jury. Up to this, we kind of went summary trial down in this district court. And I said, well, whatever you think, you know. But it was only then, and we were feminists, you know. It was only then we realised the jury were going to be all men and all property owning.
This is Maureen de Burke, born 1938, an Irish writer, journalist and activist, and one of the founding members of the Irish Women's Liberation Movement. She was interviewed in 2019 for the Women's Podcast.
The 1927 Juries Act, it's a 44-page document and there are 2 mentions of half the population. One is a man had to have property to sit on a jury. But if he didn't have property, but his wife did, he could sit on the jury. And the second mention was at the very back, a kind of an appendix of people who were allowed to opt out. And there was one word, women. But you had to formally apply. And what happened when you formally applied, of course, was that you were considered a nutcase. So you were objected to. In the whole history of the state, 2 women had sat on a jury. All the others who were listed, there were doctors, there were veterinary surgeons, they were all there because of their jobs. Emergencies might come in, like a doctor might have an emergency, a vet might have an emergency, and there were other things. But the one word for women was based solely on gender. And that was our argument.
And given the profile of these 2 women and why they were arrested, and various public statements they had made about landlords and private property, they were worried that they wouldn't get a fair trial if they were before a jury that consisted of men and property owners. And they were friends, or Maureen was friends with barrister Mary Robinson.
I don't know that I even planned to ask her, but I bumped into her or something one day and I said to her, you know, Mary, we're going to come before 12 property-owning men. Now, I would like to protest, but on the other hand, I don't want to be sent down for contempt of court. So what do we do? And of course, Mary, being Mary, said, well, there's only one thing to do. You have to challenge the Juries Act.
So that's what they did. And the case was first heard in the High Court, and then they appealed it to the Supreme Court. And their senior counsel in the case was Donald Barrington. And he argued in front of the Supreme Court that an accused person had a constitutional right to a jury which was genuinely representative of society. And the majority of judges in the Supreme Court agreed with him. Mr. Justice Brian Walsh said that the 1927 Act was, and his words are, undisguisedly discriminatory on the ground of sex. And Mr. Justice Seamus Henchy said that excluding a whole group from jury service meant that the jury lacked constitutional completeness.
Henchy J said, and I'm just going to quote it, that the jury must be drawn from a pool broadly representative of the community so that its verdict will be stamped with the fairness and acceptability of a genuinely diffused community decision.
So fairly soon afterwards, the Juries Act 1976 was passed. And this was the first major reform of the jury system since the 20s, and it's still the main piece of legislation that governs trial by jury in this country. So the 1976 Act, of course, got rid of the requirement that you have to be a ratepayer. It got rid of any kind of gender discrimination.
So when that was swept away by the Supreme Court, holding that it was invidious discrimination against women, and also invidious in the sense that there was no necessary relationship between intelligence and the ownership of property.
And from that point onward, the main requirement for serving on a jury is that you need to be on the register of electors.
Jury trials are conducted for more serious criminal offences, tried in the circuit criminal courts. For offences such as serious assault, theft, fraud and drug offences. And in the Central Criminal Court for murder, rape and sexual assaults. Unless those courts are deemed unfit for jury trial in a particular case. For example, in cases where jury intimidation is feared. In which case, trials will take place without a jury in the Special Criminal Court. So what is it like to sit on a jury? What is the process of a jury trial and how is a jury panel selected?
I can remember my first jury trial in 1979 and just realising as I did it the amount of preparation that my colleagues did when they were doing cases. And it's something you can only learn from the doing. And that's one thing I'll say. Secondly, I did a lot of work in front of the Special Criminal Court in the 80s. And I actually appeared with Sean McBride in a case of capital murder where the death sentence was passed because it was before 1990 when we still had it. And I can still see the presiding judge taking a small scrap of black material and placing it on top of his horsehair wig and pronouncing the death sentence. And I will certainly remember that forever.
Just to give you a bit of context, as a judge of the Central Criminal Court, we deal with rape and murder and associated offences. So first of all, when it comes to information that a jury gets, at the beginning of a case, the prosecution counsel will open the case. That means is give a speech and explain the process, explain everyone's roles, give a short enough summary of the legal principles, starting with the presumption of innocence, the burden of proof and the standard of proof, and then tell them a little bit about what they expect the evidence to be as well. So that's a sort of an introduction. So then the evidence is called. That can go on for days, it can go on for weeks. At the end of the case, you're going to get a summary from me. Jurors now get more assistance. It's not just them trying to scribble down everything that a witness says and sometimes missing the way it's said. They get help from the judges. You have the option of transcripts of any of the witness's evidence. So that is a written record of everything that a witness says to take into your jury room with you if you wish. In addition to that, they are allowed to hear what's called a DAR, which is digital audio recording. In the courtroom, everything is recorded. So they can have that played back. And then they have the option of looking for more information. And that's something that has become much more frequent as a consequence of a new act in 2021. We always say at the beginning of cases and then sometimes during a case, Please just take the law from us, take the evidence from the courtroom, and use your own experience of life. Do not rely upon independent research, online or otherwise. Do not discuss with the 13th juror, that could be family members, and certainly not online. The second last stage of the trial is, after the lawyers do their closing speeches, is the judge's charge. And the judge's charge has two parts to it generally. One is to explain the law. That to me means making law accessible, making it understood. I think this is kind of consistent with how the legal system is changing. Before, a judge could often give quite a complex charge to a jury. I sometimes wondered whether a jury actually understood what was being said. Whereas I think in recent times, the court process is much more alive to the needs of juries. Our role and function in explaining the law is to do it in a way that it can be understood. And if we don't say it in a way that can be understood, then we're failing in our duty. It kind of used to be like in the 80s, no matter what the local doctor, solicitor or priest said, it was gospel, it was sacrosanct, it could never be touched and you never question it. I think that might have been an attitude that was there certainly in the earlier years when I was practicing. That isn't the case anymore, and nor should it be.
The jury system does continue to evolve. In 2024, in the Lane case, the Supreme Court endorsed for the first time the use of the written route to verdict documents in jury cases. Route to verdict documents are prepared by the trial judge in more complex cases and given to jury members to assist them in the step-by-step process of arriving at a safe and fair verdict. The document is based on the offences with which the accused is charged and the defence put forward by the accused in the case before the jury.
When I read that, first of all, like all dinosaurs, my initial reaction was, oh, no, that's not going to help at all. But in fact, the next case that I dealt with, having read that judgment, was a murder case with multiple elements. And it was of assistance. The basic reason why it's of assistance is that if I can't put down step by step the way in which a verdict can be reached, then how can a jury understand it simply by me explaining it if I can't put it down in black and white, point 1 to 10? And if you can't make it accessible for yourself, how can you make it accessible for other people without a legal background? So having gotten over my dinosaur traits, I now do think that in certain cases, not all cases, a route to verdict is helpful. Other cases don't need it. The defences involved are quite straightforward. So yes, we are the authority on the law. The law has to come from someone in the courtroom and it comes from us. But we give it to the jury so it is employed by them in the deliberation process. And if we don't give it away in a way that's understood, then we failed in our duty. I personally feel, for now, certainly have sufficient faith in juries for them to utilise the legal principles that I give them, base their views on those principles, their experience of life, and what they hear in a courtroom. And they're the three tools that they have. The rules of law, the evidence, and their experience of life. As I said, that diverse group of people who the law, the Constitution expects will give a just and fair verdict. And inevitably, in my mind, they do.
So I think it's a developing area, and I think it's just a good example that shows that trial by jury is not a fixed concept. It's not static. It's been changing for hundreds of years, and it's going to keep changing. So I think it's worth bearing that in mind.
For me, I think the big changes, both in law and practice, really come around sexual offences. So, for instance, in 1981, there was a very large reform of the law, the Criminal Law Rape Act of 1981, which made provisions for and against the question of questioning people on previous sexual history. And that was, at the time, a big change. Secondly, the way in which cases are run has changed because we now have video link evidence. And that can be done for reasons that a person might find it difficult, a complainant, a victim, to come to court and speak right in front of the accused. The other aspect is not just in relation to adults, but in relation to children. I think the system is a lot more friendly to children now. So a child doesn't have to sit in front of a court, or a child doesn't have to sit in front of a video link and start and tell his or her story. One of the great features of the lists nowadays are historic sexual abuse cases, which could be delayed 20, 30, 40, or even 50 years. And there's cases like that going on very commonly now. And 40 years ago, if a case had been brought to court, which was 40 years of age, it wouldn't have been brought to court. Or if it had been brought to court, it wouldn't have survived a minute. So several things have changed very much in Irish society. Firstly, there's the understanding of delayed reporting of sexual offending. So people are no longer inherently suspicious of the same, provided there's an explanation. And secondly, in the area of coercive control, which often has a relationship to sexual offending. And that, I think, in particular, is a matter which Irish juries now understand. Both the judges and the juries understand and get these things. I mean, one shouldn't be complacent, I think.
I think that we have come to a stage where the rights of victims, in terms of privacy rights, their rights to be respected during the course of the court process and not to be, as the Victims Directive says, re-traumatised or re-victimised, they've become very live in recent years. I think kind of what happens in the legal world is that the issues become live at ground level when society changes or requires change of the legal system. And then over the course of, sometimes it can take a decade, less, more, then it comes to the Supreme Court or the Court of Appeal, and they set down parameters and they set down rules that gives us help in determining legal issues. So that balancing of rights, I think, is going to be the subject matter of further discussion, because we're only now beginning to really recognise the rights of victims at the appellate court level. And having recognised them now, I think probably the next stage is reconciling that with the accused right as well. All of it has to reflect how society is moving and evolving, and we have to evolve with society.
The need for the jury system to continue to evolve is particularly relevant when it comes to selecting a jury panel.
So, people have different perceptions about how the makeup of the jury will actually affect the outcome of a case. You know, in the past, people thought it was very important that certain religious or political interests were represented or weren't represented. And we sometimes see this spilling through in cases where people think that the gender makeup of the jury will have an impact on the decision.
When you're sitting in a position of neutrality, looking at the courtroom and looking at what's going on, you have probably a sharper lens to see things. So oftentimes when a jury's been impanelled, if it is a rape case, for instance, of perhaps a girl in her 20s, I've often seen, because there can be challenges to jurors or potential jurors. So what that means is that 7 people can be objected to by either side. That is a challenge without cause. They don't have to say why they're challenging. It could be anything. And the legal teams get very little information about the potential jurors. It's not like the US where you'd have all manner of information. So sometimes I think the general location as to where they live is made available, and possibly employment. But that's it. So negligible information. And I've often seen in rape cases the solicitor for the accused object to women. And if it is a younger victim, young women. If it's an older victim, sometimes older women. It's something that I see quite a bit. And what I find odd about it is that I can see the panel witnessing what's happening. People are clever and they're astute and they can see exactly what's happening. And both men and women, I won't say find it amusing, but are bemused by this process where women are being objected to because, for whatever reason, they are perceived as not being in a position to be impartial when it comes to jury decision or jury deliberations. So that still happens, that type of preconception of women's ability to judge impartially and unemotionally, because that is required of a jury. It's to give a clinical, clear decision, and they do. And men and women are as capable and bring different things to the table. So that is something that will have to change over time. And I just wonder, having looked at, which I did for this purpose, De Burke again, how we still have this archaic mindset. But as I said, society is better because those being impanelled or the jury panel itself, they are bemused by this process.
I mean, even the idea that we still allow people to challenge a certain number of potential jurors, more or less just based on their appearance, is probably a bit anachronistic at this point. So you can challenge people, but you don't really have any information other than what's visually in front of you. One thing I think we could do would be to look at whether the jury really is a representative body or not. So historically, the jury was not a representative body. They didn't represent the wider community. They represented a small slice of the community. And over the past century or so, it has evolved into something representative. That's here in Ireland and in most other countries that have jury trials as well. We don't have limitations based on gender or power or prestige. In most countries, the restrictions now for sitting on a jury would relate to age, mental capacity, criminal background, and whether you're registered to vote. In Ireland, we also require that people are citizens of our country. And I think maybe we could ask ourselves, should someone who's been living here for a number of years, who is part of the community, but might not be an Irish citizen, should they be liable and entitled to sit on a jury? Other countries don't have the same restriction on citizenship that we have. I'd also suggest that the categories of people who are entitled to be excused from jury service are too broad. So in comparison with other countries, we have, I think, an excessive list of people who essentially don't sit on juries. For example, university lecturers, teachers, and students can all apply to be excused from jury service. Doctors, nurses, pharmacists, vets, people like that can also apply. Anyone who is connected with the criminal justice system or the justice system more broadly can be excused from jury service. So there are all these categories set out in the legislation. And I think if we really want juries to be representative, almost everyone should be required to sit on them and should be entitled to sit on them as well. One thing I would say is that in the past, so going back to the 19th century, 18th and 19th centuries, there were definitely cases where the jury system failed for one reason or another, through corruption or incompetence or because of violence or unrest. But those cases were the exception and not the norm. When things were peaceful around the country, there were thousands of jury trials every year in civil cases, in criminal cases. And in the vast majority, they worked well. People took their role as a juror seriously. And I think that's still the case. So we can poke holes in the system and there are things that can be improved. But fundamentally, it does seem to work in the vast majority of cases. And people like the idea of lay participation. A flawed jury is better than no jury. So I think it's worth remembering that it works most of the time, and in the past it worked most of the time as well.
I do think the jury system is absolutely first class. I don't think there is a better system and will never be a better system.
A first-class system that has evolved over centuries and continues to evolve in line with Irish society to ensure that the right to trial by a jury of our peers and the right and obligation of citizens to be a member of a jury is at the heart of our criminal justice system, so that citizens have a key role in determining the guilt or innocence of their fellow citizens. You have been listening to the Irish Courts Podcast, a curious broadcast production with the Court Service and the Judiciary. Thank you to our contributors, Associate Professor Niamh Howlin, Senior Counsel Patrick Gageby, and Miss Justice Caroline Biggs. Audio extract of Maureen de Burka are courtesy of the Irish Times Women's Podcast. Original music score by Jerry Horn.